So coming up next is going to be our panel that looks at civil rights protections and emerging technologies. For our virtual audience, you can go ahead and join us in our next session. And it is my pleasure to welcome Elizabeth Laird to the stage. Elizabeth serves as the Center for Democracy and Technology's Director, Equity and Civic Technology, where she leads the organization's work in this critical area. Her work engages civic institutions to promote the responsible, equitable use of data and technology to improve outcomes for individuals and the public good, while ensuring it does not come at the expense of privacy and civil rights. And she will introduce our panel. Please welcome Elizabeth.
Thank you, thank you. Can you all hear me okay? Yeah. All right. Wish me luck in following lunch and talking about AI and civil rights. I'm Elizabeth Laird, and I just want to thank you for being at this session and coming to BenCon. We've heard a lot about emerging technology and how this is a nascent issue, and we were grappling with things for the first time. I'm going to talk about something that's actually been around for a long time, and that is civil rights protections. Literally decades, in all of our roles, we have needed to make sure we are not discriminating against anybody on the basis of protected demographics. So we're going to maybe get to grapple with some long-standing bodies of law and concepts, which may feel like a bit of a break from, oh my God, like what are we going to do with that? But before we do that, I wanted to just thank the Beck Center and the Digital Benefits Network for making space for this conversation. The next, today and tomorrow are going to fly by, so I really appreciate making space as much as we're talking about innovating with AI and how it can improve the delivery of public services. We're also just as obsessed with the ways that it can go wrong and that we can and have to do both of those things. And I think it's a credit to their leadership. And so you can't put me on the mic at BenCon without acknowledging Ariel and Liz, who have put so much work into planning this session. I think we started talking about this session in January, so there is a lot of time and attention that goes into that. So before we dive into my session, I would like to just thank them with a round of applause for all of the work that they've done in putting this together and prioritizing the conversation about civil rights. They didn't have to do that. And in a lot of conversations about AI, they're not. So I'm actually going to be joined right now by a couple of, this is a fireside chat, so I guess fellow fireside chatters. So just imagine, there's a deep fake AI fire roaring behind us. We have our cups of your favorite tea. And those two people are Clarence Okoh and Henry Claypool, and there is two really important things that you know about their bios. One is that they are very impressive, and two, I am not going to read them to you. So Clarence is recently with, actually where we are now, Georgetown Law Center for Technology and Privacy, and Henry is joining us as a technology consultant with the American Association for Peoples with Disabilities. And so we're going to do a different type of introduction for them. So please join me in welcoming Henry and Clarence to the conversation. Is this on? Okay. My worst fear as a speaker is to get up here and either your slides don't work or the mic doesn't work. So maybe the hardest part of this is over. So I do have questions that I prepared for the panel, but just to keep it interesting, I'm going to ask them something that I did not tell them about. And that is, this is a niche issue. It's increasingly in, pop culture and the zeitgeist, but I would love to hear you talk about as a way of introducing yourselves of all the issues and all the world and in all the way that you could fight for social justice and human rights. How in the heck did you end up focusing on tech and civil rights? So I'll start with Clarence.
Good afternoon, everybody. I'm from Alabama, so we're going to try that again. Good afternoon, everybody. Appreciate it. So my name is Clarence Okoh. As Elizabeth said, I'm senior attorney over at the Center on Privacy and Technology here at Georgetown Law. Super excited to be in conversation with you all today. One of the things, actually, in reflecting on this question, I was thinking about going back to the third grade. I remember I had my first black teacher in the third grade, and we had to do a lesson on civil rights icons. And I was very upset at my third grade teacher because I did not get Dr. King. I did not get Rosa Parks. I got some dude named Thurgood Marshall. And I'm like, what is a Thurgood? Like, who, why? And from that moment and learning about the work that he and so many others at the Legal Defense Fund trailblazed in the field of civil rights and really in our democracy, that was an invitation to me to really understand my role in this broader historical context, this journey that not only African Americans, but so many marginalized populations have been on in this country to fully realize the promise of our democracy. So that was one icon that I developed in the third grade. But it was interesting because before I met Thurgood, if you asked me who I wanted to be, what I wanted to do when I grew up, I wanted to be president of NASA. Both of my parents come from a STEM background. I was always fascinated with this idea of space exploration, science, innovation. And so it was this weird combination. I distinctly remember sitting down with my mom one day and her asking me, what do you want to do? And I was like, I want to be a Supreme Court justice like Thurgood Marshall, and I want to be the first black president of NASA. Like, this is totally a doable thing. So
there's still time.
There's still time. So it's very fascinating that that dual interest, something that I had not thought about in almost 20 years now, is still kind of shaping so much of who I am and the work that I do. So I've been able to really pursue that in a professional context, starting out at the NAACP Legal Defense Fund, realizing that childhood dream, leading work around the implications of emerging technologies on the civil rights of Black and brown communities, and have had the opportunity to do that work in a number of instances, including now here at Georgetown. So that's my little buttoned up version of the answer.
All right, thank you, Clarence. And I should be truthful. I did give them 2 minutes heads up that I was going to ask them this. So they did have a little bit of time. So Henry, I feel like when you board a plane or your plane has landed, they say, we have a lot of choices when you're flying. We appreciate you for choosing insert whatever airline. So of all the choices that you had, how did you end up working on tech policy and civil rights?
Well, mine is a two-part answer. And so I think first was I acquired a voice, and now I'm fully voiced. I acquired a disability when I was in college, and so it was a really new experience, and I thought, this kind of sucks, being excluded from everything, or separate but equal. And I really didn't have much of an awareness of, I had learned in school about civil rights issues, and they were intellectually curious and wanted to do the right thing. But when it was visited on me, it became much more of something that I felt passionately about. So that ended up becoming a career. But the tech part came when I was working at the Department of Health and Human Services right after the Affordable Care Act had passed, and we'd done a decent job of implementing the law. And they were starting to do enrollment, and there was some really interesting thing going on with technology. And I thought, oh, that's really great. I'll go out and change the world. And what I found was that, oops, many of the same issues are kind of bedeviling our efforts to leverage technology to benefit the population that I happen to belong to. So.
Thank you, Henry. So I'm both a moderator and a chatter, so I'll just give you my background and how I ended up talking to y'all today. So before I was in this role at CDT, I spent 7 years at a nonprofit advocating for the better collection and use of data in the education sector. The reason being, my previous roles, I was seeing a lot of money coming into education, and I asked, well, how do we know if any of this is actually moving the needle for kids? And the answer was, we don't. We don't have information about that. And so that is what spurred my interest in it. And so I spent 7 years advocating to federal and state policymakers to build data systems. And it's interesting when you hear how this conversation is evolving on my own journey on this, but we need to build more data systems and collect more data. We need to follow kids over time, and we're going to share it with Health and Human Services and labor, and we're going to do all these amazing analyses. And so then I went to state government. And within my first year there, the state passed the most restrictive and conservative student privacy bill in the country. That state is Louisiana. And its claim to fame is still being the only student privacy law where if you violate it, you're subject to criminal penalties, including time in prison. And so they looked around and like, well, who knows something about data? And they, was voluntold it was me. And I learned firsthand what happens. The reason that they passed that law is because the state had lost the public's trust in their ability to responsibly collect and use that information. And so the pendulum swung way in the other direction. And I spent 18 months traveling the state, talking to teachers about how I was going to try and keep them out of prison while also making sure they can continue to serve and educate kids. So I did not, maybe a common theme, I don't know that any of us set out to do this, but maybe Ferris Bueller life comes at you fast, and this is where we are. And so I got really interested in how do you do both of these things? How do you both make sure data and technology, now we're talking about AI, work for people, but you're just as obsessed and thinking about how can it go wrong and for whom, and putting in place proactive guardrails to prevent that from happening in the first place. We've already sort of jumped in and started throwing around the term civil rights, but I think it's important to actually talk about what we mean by that, because it can mean a lot of different things to a lot of different people, and especially at AI, you hear terms thrown around like, we need to mitigate bias, we need to ensure equity, we need to manage disparate impact. It can also mean, I hear it used as, well, let's just not do bad stuff to people and everything in between. So for purposes of today, I wanted to ground the conversation in what it means to us, and that you can also be thinking about what it means to you and your work. So I'm going to start with Clarence. When you hear about civil rights and AI, what does that mean to you?
Yeah, so I think a couple of quick thoughts come to mind. The first is that, as you all are probably aware, like, we are living in this era in which emerging technologies like artificial intelligence, but other algorithmic systems as well, are reimagining historical patterns of racial and social inequality, and is doing so at a scale and a pace that is really kind of confounding the law's ability to respond to. Civil rights law has a long-standing history in this country, really dating back to the Reconstruction era, the 13th, 14th, and 15th Amendments, and a series of laws that were passed after the emancipation of enslaved persons. And the project of civil rights law has always been about filling in that gap between what was written on the Constitution and the actual practices that unfolded in this country. Unfortunately, as you all are likely aware, those challenges remain with us today. And unfortunately, many of these data-driven systems are designed in ways where they are, again, intervening in these long-standing historical patterns of social inequality, leveraging that data to imagine futures that perpetuate and reinforce that inequality. And we see that in a variety of domains, right? Whether it's in the educational context and the policing and criminal legal system, whether we're talking about healthcare or whether we're talking about public benefits, we're seeing the ways in which the design of these systems don't contemplate or don't even acknowledge the existence of these civil rights protections, that we see inadequate guardrails, as Elizabeth was saying, from a policy perspective, from a regulatory perspective, from a juridical perspective around how these technologies should be designed and implemented to be consistent with these protections. And we have to understand what's at stake, right? If we don't design and implement these guardrails, if we don't put in place the protections that translate those legal concepts into a kind of compliance regime, what ends up happening is civil and human rights crises. I've seen that in my work. I've seen, for example, how fintech companies have leveraged educational data to discriminate against students who attend HBCUs and MSIs. I've seen how law enforcement agencies have been able to access student data, including histories of childhood abuse and neglect, looking at students' grades and their attendance records, and using that information to determine which students would be subjected to surveillance and ultimately exclusionary discipline. And I've seen so many other examples in which these technologies expand the presence of law enforcement and carceral entities within Black and brown communities, whether we're talking about drone surveillance or we're talking about facial recognition, automated license plate readers. So there's this kind of uncritical absorption, consumption of these technologies, particularly in the public sector, that raises these critical and urgent civil and human rights crises. And so when we're thinking about what does it mean to think at the intersection of emerging tech and civil rights, that's what I'm thinking about. What is at stake? Who is it at stake for? What future are we going to live in? Are we going to allow for histories of scientific racism to define our future, or can we chart a new path that lays civil and human rights at the foundation to build the type of society that all of our communities deserve.
Okay. Go off, Clarence. Henry, what does AI and civil rights mean to you?
Okay, well, Clarence, ditto, and then some. But if we look at disability, it's really an interesting kind of case study, because many of my peers in society, I think, have this general theme that, we can leverage technology to make things better for disabled people. And there's a long history of that. I mean, it's used today in many places to make people's lives better in really meaningful ways. And what I'm going to say, I don't want to cast shade at all on those efforts. But the reality is that it makes it a little difficult sometimes to begin to say, wait a second, with these data-driven technologies, we've really got some foundational issues when it comes to disability that we have overlooked, and I think still today we really need to kind of double down and do some further exploration, and then, as I was reminded at lunch, some problem solving. But they are the foundational issues of the fact that disability is a really heterogeneous experience. It's different people with different things in their lives, from mental health to developmental disabilities, paralysis, a history of chronic health conditions. People are now identifying as disabled people. And all of this is really undercounted and still heavily stigmatized. So we don't show up in the data in meaningful ways. If you think about demographic questions, how often do you see disability included with race, gender, age? It's typically not there. And so this, is a real challenge when we're trying to leverage these data to make people's lives better. And I think that's probably there's one other thing. I would just mention that it's a vastly undercounted population. It's very similar to the history that I think Clarence is reminding us of. And disability has been around for a little while, but these layers of stigma are really difficult to unpack. They're both internalized and they're, broad in the society. So I think we can't underestimate the challenges of dealing with those issues to leverage this technology.
Henry, I'm going to come back to you, so
okay.
Heads up. So as Clarence talked about, civil rights protections related to race and sex have been around for quite a long time. The Civil Rights Act is from 1965. What not everybody may realize, though, is that some of the disability protections came around later, including some in the 90s. So Section 504 of the Rehabilitation Act was enacted in 1973, 10 years after the Civil Rights Act. The American Disabilities Act came along another 15 years after that. So as we're thinking about civil rights, I think it would be helpful to, and you've already talked about this a little bit, but where are there commonalities when you're thinking about the civil rights of people with disabilities, and where might there be important differences for us all to think about as it relates to the use of AI?
Sure. I mean, one of the phrases that often comes out in the disability community is the disability rights are civil rights. And sometimes the community has a difficult time remembering that when it comes to doing the important work around race and other issues, and becomes preoccupied just with pursuing a disability rights agenda. But I think that is something to remember, and how you can recall this is if you happen to look at the provisions of the law, you'll notice that they're actually quite similar. In fact, the ADA, which is, well, you've started with a timeline, right? So we've got 73, which is quite early, at least in my life. It was before I became disabled, but I had an injury in 1982, and then in 1990, the Americans with Disabilities Act passed. And so I had an experience of what it's like pre and post. And so it is an evolution. But I think when you do look at the provisions, the disability rights law really borrows, I think, almost verbatim in some phrases, like public accommodations are worded, I think, virtually the same. But since there is this Rehabilitation Act of 1973, that covered entities receiving federal funds. And so that part of the Civil Rights Act, what didn't need to be replicated so much in the ADA. But what was really important in there, I think, for this conference is there's a provision pertaining to state and local government. So they are named directly. Why is that important? And I think in the disability context, if we think about our society and how we've gone about addressing the issues associated with the issues of ableism, and I think that's a relatively new term to state government, but the state agencies have been charged with programs and doing things for the population. And that puts the intersection right at that level. So if you're administering a benefits program, you're going to now have to deal with civil rights issues, and you're operating a program. So the Department of Justice is actually out there surveying a landscape and monitoring how various states are kind of operationalizing certain benefits programs. And it's can be quite, it's a microscope that you don't really want to operate under. And so it's great to be looking to their office for guidance and see what types of learnings are available. But I don't know if I've gone beyond your question. I think I'll stop.
The limit does not exist.
Okay.
Actually, Ariel would beg to differ. Ariel would say the limit is 2:45 and not a second over. She's looking at me from back there. So for folks who were in the room for the panel this morning about AI and what's the current status, there was a question about what are real-life use cases where AI can support the delivery of public services. We're going to put our own spin on that and talk about what are real-life use cases where public agencies have run afoul of civil rights protections. And that's not to sort of throw our hands up and say it's hopeless and we shouldn't do it, but it is to say the more we know, the more we can identify it and do something about it. So I'm going to ask my fellow chatters to give an example of when you've seen that and to try and be specific about the type of civil rights claim. I mean this in a legal context, and I think it's important because there's a big body of work that surrounds this, and so knowing the right terms and what to look for, it's like once you start to see it, you'll be able to spot it more easily in the future. So speak to the actual claim that's implicated, the way that AI was used, the type of harm that was inflicted, if any, and then what happened as a result. So Henry, I'm going to give you a break, and I'm going to go to Clarence and then back to you.
Can you hear me? Okay, awesome. So an example I was kind of previewing before, which actually, and I'm sure this conversation has been had, right? Artificial intelligence is a very capacious and undefined term, and quite frankly, a lot of the harms that we see unfold in communities don't necessarily even implicate kind of an AI system, but something that gestures at it, right? A lot of times there's just simple data sharing practices or algorithmic systems that can create harm. So I want to provide an example of one of those. About 3-4 years ago, I'm getting old, there was a Tampa Bay Times investigative report that had uncovered this really expansive predictive policing program in Pasco County, Florida. What was particularly egregious about this program, we had predictive policing all over the United States. What was egregious about this program was that it was a program that was focused on school children, and it was done in partnership with the school district. So the way that the program worked was the school district provided access to, through a a data sharing agreement with the local sheriff's office, provided access to a range of confidential student records. So everything, as I was mentioning before, their grades, attendance records, discipline records. They also had access to histories of childhood trauma and abuse. If, for example, a kid had a parent who was in the criminal legal system, that was another criteria they were looking at. I mean, something as simple as a parent's going through a divorce could land the kids on this system. So what happened is they would take that data and they had developed this kind of in-house rudimentary algorithm whereby they scored the children who they believed were, quote unquote, at risk of developing into prolific criminal offenders. That's like verbatim from their intelligence-led policing manual. What happened is that they evaluated at one point, I think at its height, over 18,000 school children, and this is a suburban community outside of Tampa Bay. So 18,000 school children had their data reviewed by this system, ranging from ages pre-K all the way through 12th grade, and we even had students who were in adult educational programs who were also a part of this program. What happened is that students who were flagged by this program, they were placed, a certain segment of them were placed on this at-risk youth list. This list was given to school-based resource officers. For folks who aren't familiar with the educational context, these are cops in schools. So the cops were given the list of the names of kids who were on this list, and they were instructed to surveil them to such an extent that they would either want to move or sue the county, and that's another direct quote. So what that looked like is they're calling these students into their office once a week, twice a week, however many times. They're conducting randomized home visits to their families and to these young people at all hours of the day and night. We have reason to believe that students who were subject to this program were subject to higher rates of exclusionary discipline, so suspensions, expulsions, so on and so forth, as well as greater contact, obviously, with the criminal legal system, so much more likely to have or be referred to law enforcement. Layered on top of that, in Florida, there's this law called the Baker Act, which some folks may be familiar with. The Baker Act is a law that essentially allows for, at least in practice, the involuntary psychiatric detention of children for up to 72 hours, and it's often done without parental notification or consent. So students who were on this list were often Baker Acted, and vice versa. Students who were Baker Acted often ended up on this list. I don't have to kind of give you all an in-depth crash course on civil rights law to understand intuitively that this is a deeply problematic and deeply unlawful system. So we developed a series of folks, it was over 90 state, federal, local organizations, teachers, parents, kind of coming together in response to that to try and figure out strategies, interdisciplinary strategies to push back, challenge, and undo this program. And to walk you through some of the legal components, because we can go into details about the campaign strategy at some other time, but the legal components I think are really important to understand here, kind of what issues are at play. Let me start by saying at the onset that when we're talking about emerging technologies and their civil and human rights implications, we have to think very broadly and expansively around what civil rights looks like. So we have our traditional laws which are implicated. In this case, it would be Title VI of the Civil Rights Act. This is a law that prohibits any person who receives, any entity that receives federal funding from engaging in disparate treatment or disparate impact based off of a protected characteristic, in this case, race, right? So we know that the criteria that were being used would have a disparate impact, and we actually have a forthcoming report from the Legal Defense Fund that kind of explores some of this. But the criteria that are being used, things like student discipline, those types of data are infected with histories of racial bias and discrimination, right? We've known ever since we've gotten data from the Office of Civil Rights at the Department of Education, we've known that there are these disparities with respect to that. And in fact, all the criteria that they use, we did this analysis and found all of these criteria have a disparate racial impact on Black and brown students. So that's kind of the layer number one. Let's take it back a layer, actually. Pasco County, by the way, is still to this day subject to, it's one of several hundred school districts around the country that's still subject to an active desegregation order from the 1950s and 60s. That means from a legal perspective, they have not integrated their schools since the era of apartheid in the United States of America. So here we are again, having a community that has not reconciled with this past, engineering futures of racial injustice into the future, right? Let's think about that for a second. But not only is there like traditional civil rights at play, and I'll wrap this up real quick, there are other protections that we should understand as civil rights at play. For example, FERPA is at play in this case.
FERPA?
FERPA is, I always get this acronym wrong, Family, Education,
Educational Rights
and Privacy
Act.
We did it together. Teamwork makes the dream work.
It literally takes a village.
Yes, it takes a whole village. So FERPA protects students from unauthorized redisclosure of educational records. So essentially, when these records are being handed over from the school district to law enforcement agencies without an educational purpose, they're supposed to get parental consent before they do that, parental notification and consent. That didn't happen. So we have FERPA violations. So we're keeping track. We got a Title VI violation. We have longstanding segregation issues, and we have FERPA. On top of that, we have the Fourth Amendment. The Fourth Amendment protects from what? Unreasonable searches and seizures. So when you're searching students' data without, again, having a warrant in place and there's no exigent circumstance, that raises Fourth Amendment considerations. By the way, for FERPA, there's federal FERPA, there's also a state privacy law in place in Florida as well protecting student rights. So you can kind of see through this exercise, there's a range of protections that exist for students when it comes to, and for our communities writ large, when it comes to the adoption of these technologies and their implications for our communities. So that just kind of gives you an example of the types of laws that are being implicated and the ways that, quite frankly, there were a number of agencies involved in this program. It wasn't just the sheriff's office and the school district. The Department of Children and Families was involved. Local mental and behavioral health care systems were involved. They were all engaged in this data sharing with the sheriff's office, not attending to or thinking about the implications for civil and human rights for those young people.
Great. Thank you, Clarence. I want to tease out a couple of things, and we'll go to you, Henry, for another example. But so Clarence used the term disparate impact. That is a type of civil rights claim. What that means is that is the application of a neutral policy. So we're not actually setting out to treat anyone differently, but when we look at what happened after the fact, that is what occurred. Another one that is baked into what Clarence talked about that I wanted to tease out, and this is to sort of make us all a little bit uncomfortable before we feel a little too smug about, well, I'm glad I don't live in Pasco County, like this is happening in your communities too, is something called disparate treatment. That is where you actively treat someone differently on the basis of a protected characteristic. And so what Clarence was talking about was a predictive analytics. And oftentimes those predictive analytics do include elements like a student's race or their disability. And how do I know that? I know that because we conduct annual polling of parents and teachers and students. And so 60% of the teachers who we surveyed say that they use predictive analytics that could include protected demographics to identify students who are at risk of dropping out, and a third do it to predict who might be at risk of committing a crime. You may be thinking, like, why would anybody ever do that? Like, that sounds like the worst idea I've ever heard. Well, because oftentimes these are really well-meaning people. They're like, well, we want to figure out who is going to be at risk in school and get them the resources that they need. We want to know who might, run afoul of the criminal justice system so we can intervene and figure out what's going on and help them. But the reality is that oftentimes that's not what's happening. And even when it's maybe not achieving its intended outcome, there's not a lot of analysis of how did this go? Did it achieve its intended outcome? Did we actually lead to disparate outcomes by protected characteristics? So, and I will say, like, in my role in government, I think we talked about not necessarily doing this, but doing similar things where we really had good intentions, but that's not enough. And that's why it's so important to understand and, like, ask yourself, if you're including a protected demographic in an algorithm, you should stop and be like, okay, why are we doing it? Do we know this is working? Is this really the only way we can achieve this, outcome? And it should really be like a red flag for you if you see that. So that's what I hope is the purpose of this session, is to start to name, like, what are those concrete things that you can look for, both on the front end and the back end. So Henry, I wish you a lot of luck in following up that story with what you've seen specifically in the public benefits context.
Sure. Well, mine is much more of a beneficiary or kind of advocacy perspective, so it lacks the legal kind of points that I think were so well put together here. But it's still important. So the state of Idaho operates a Medicaid program. There are these things called home and community-based services, and they're highly desired by people with significant disabilities because when your disability has certain types of functional impairments, you become eligible for these waiver programs. And once you're in that program, then you get a far more generous package of benefits. So it's something that's really sought after. Yet you have to go through this functional assessment. And the state of Idaho was, these functional assessments are, long time, algorithmically driven functional assessments. You ask a series of questions, and then you get whether or not this person is going to receive the package of benefits. Well, as we see automation starting to take over how states are doing these functional assessments, the outcomes are becoming a little more pronounced. And so what was found in the state of Idaho was that there were a number of people who had a long history of receiving a certain package of services, and that started to change for them. In fact, they were receiving a reduction in service. And fortunately, there's a group like the ACLU that was active in the state of Idaho and represented the individual and took their case to court. Now, it wasn't challenged on these civil rights grounds. It was really challenged on kind of due process, because the state needs to go through a series of steps before they're going to change and reduce the amount of services to individuals. But they didn't do that. And instead, they were saying, look, this is our new tool, and it's telling us you don't need as many services as you're getting. And we have been, probably over allocating resources to you for a long time, and we want to change that now. And so obviously, with sweeping changes like that, you applying it to this really heterogeneous population, it's going to be quite difficult. And so they've ended up in court, and they've been able to now get some relief for the individuals. But the way the state is doing it still, they're using their algorithm in their system, but anybody that is concerned that they have a reduction of services can raise their hand, and then the state will look at the situation and take some steps to remediate. I'm not sure exactly how well that's going, but you can see one thing we do know is that people in these circumstances are often not their own best advocate. They are really just interested in getting the services they need, and if the state is going to make an adjustment to them, they're probably more inclined to say, well, let me see if I can get by with what I'm getting now. I don't want to turn this into a lawsuit. So you can see how this pervasive application of a new technology has really disadvantaged a population that isn't inclined to advocate for itself for all of the structural reasons that I really haven't mentioned here, but I've thrown out ableism. And the fact that people internalize this is very common.
So thank you. So 45 minutes is not enough. I don't want to end on that note, though. Sorry, Ariel. We did get started a couple minutes late. But who's counting? I am. So I've seen lots of nodding heads, some shocked faces, as you've heard some of these examples. I would like to end with assuming that we've hopefully convinced you that this is important. Also that it's your job too. If you're working on data and technology, if you are engaging in these issues, you need to understand what these things look like so you can prevent them from happening. So what advice, Clarence and Henry, would you give to public administrators who are bought in? They're like, okay, we want to make sure that, we use AI in ways that are consistent with the values of civil rights. What is one piece of advice that you would give them? Clarence.
I'll just jump in and say, form an inclusive team. Get people with really diverse backgrounds. Get the people that you probably don't want to talk to and talk to them first. And make sure, this transparency is actually going to serve you well if you go about this. So an inclusive team would be great.
And I think building off that concept of an inclusive team, in almost every state, say almost every. There are some states where, civil rights isn't a priority, including my home state. But there are going to be offices of civil rights within your state's attorney general office. You will have civil society organizations like the organizations that we represent. They're academic institutions. There's a whole bunch of folk within your communities that offer expertise on how civil rights compliance can look and play out, and in making sure that there is space and designing structures to include those voices is really critical. The other thing I'll say is this. So there's this concept, I'm sure folks have talked about, techno-solutionism, which is like a really bad problem in the public sector. And it's this idea that we can turn to technology to solve social problems. So, if there's an issue with student discipline, there's an app for that. If there's an issue with uptake on a particular service, there's a new AI system for that, right? And I think we have to embrace a different approach. Rather than saying, how can technology play a role in addressing X, Y, or Z issue, we have to first ask the question, should technology play a role in this arena, period, right? Are there other approaches, other strategies, other solutions that are a better fit for this? When you look at other regulatory regimes that are developing around the world, obviously there's, I think, room to grow in almost all of them, but there is a far more skeptical approach embedded within those approaches. There are these kind of categories of technologies that present such a high risk of violating individual rights that they're just not allowed to be used in the public sector. And I think we should embrace that here in the United States. There are some places that are doing that. I was very encouraged to see New York State, for example, take a ban on facial recognition and biometric technologies being used in public educational systems, right? There are some challenges and nuances around that ban, but I think that's the kind of approach that we should be thinking about. That is always an option, to say no to the technology and instead turn towards your community partners to identify the solutions that are actually going to solve the problems that are plaguing our communities.
All right. So to wrap up, if you remember nothing, please remember these 3 things. Number 1, civil rights are not new. There's a lot that is new, but civil rights protections are not new. They have existed for decades. So because of that, remember the second thing, which is that there are existing legal bodies. You probably have lawyers in your agencies who work on this. You may not talk to them when it comes to tech, but you can and should. And there are organizations like ours who have been working on these issues for a long time. So please know you're not starting from scratch. There are a lot of us who are ready and willing to help you. And 3, congratulations, you are all hired. You are all now charged with not just promoting the value of data and technology, but also looking for the ways that it can go awry and finding those things and making good trouble. So with that, please join me in thanking our panelists. And I hope everyone has a great BenCon.